Before being confirmed as Attorney General in May of last year, you were first nominated by President Obama to serve as the United States Attorney for the Eastern District of New York, and you were originally appointed to the U.S. Attorney post in 1999 by former President Bill Clinton. The existence of Secretary Clinton's private email server was first brought to light in March of last year. Given that she was a political appointee of your current boss, and more importantly, the wife of your previous boss, why did you not see fit to recuse yourself from the investigation?
Considering the matter, there was no connection. There was no need for a recusal or an independent prosecutor.
A mere week before Director Comey's announcement, you met privately with your former boss, former President Bill Clinton, on your plane at the Phoenix airport. Why was this meeting, particularly in light of your previous appointment by President Clinton, not grounds for recusing yourself?
With respect to my conversation that I had with former President Clinton in Phoenix, it was a conversation that was held on the airplane, on the tarmac. The former president indicated he wanted to say hello, and I agreed to say hello, and we had a social conversation. Nothing of any relationship to the email investigation was discussed.
Why did you defer to Director Comey when the responsibility is yours?
Let me be clear that my decision was to accept the recommendation of the team of agents and investigators who worked on this. And these are the career attorneys as well as the dedicated investigators, including the FBI director.
I've noted that the Justice Department over the last several years has prosecuted several servicemen for doing the exact same thing that Secretary Clinton did. In one case, actually reached a judgment of a court that prohibited that serviceman from ever having a security classification again. People think that there's a different standard between the servicemen and Secretary Clinton, and the fact that the language is almost synonymous, if not synonymous, saying no prosecution of Secretary Clinton and prosecution and conviction of the servicemen. You have a burden, I think, to convince to the American public that you don't have a double standard.
Congressman, every case stands on its own separate facts and the application of those facts to the law. So you'd have to refer to the specific facts of the other matters that you're referring to. With respect to the investigation into the former secretary's handling of classified information, her private email system, again, I can tell you and this entire committee and the American people that all of the relevant facts were considered, investigated thoroughly, and reviewed by the entire team.
One of the service people who was prosecuted basically sent an email out that his fellow Marines were in danger. And he ended up getting prosecuted for warning his fellow Marines that their lives may be in danger. Now, here in the case of Mrs. Clinton, the private email arrangement was simply to avoid public scrutiny. So in terms of the intent of Major Jason Bresler and Secretary Clinton, one Major Bresler was doing it to save his colleagues. The other, Secretary Clinton, was to avoid transparency. Now, in terms of the bottom line, that's the hoop that you have to jump through in order to retain and regain your credibility with the American public.
So far today, you have rarely said absolutely yes or absolutely no, correct? You've mostly talked in terms of I can't answer that, or it's not appropriate, or see the FBI director. And so in light of that, and this is really a question of what do I tell the Marines, the sailors, Army personnel in my district, the veterans, the contractors, all those who work for the government with classified information. The former Secretary of State, in an unambiguous way, said repeatedly, both under oath and to the public, time and time again, I did not send or receive any information marked classified. And you're aware of that she had definitively said this repeatedly, right?
I believe her statements are on the record, and I defer you to that.
And I have referred to that. She unambiguously said something which was not true, according to the FBI director. So When you send and receive documents that are marked classified clearly, and according to her statement, 300 people have seen her email. Some portion of those people saw the ones that said secret, top secret, confidential, whatever. None of them are charged. What do I say to the tens of thousands of people that live and work in my district, that work for the federal government, including more than 47,000 Marines? What do I say when, in fact, saying something that isn't true, handling classified information in an extremely careless way, has no criminal ramifications?
Congressman, I can't speak to any cases you may be referring to involving friends or colleagues. Again, I would refer you to the description that
I appreciate
provided
that,
about
Madam General,
the
but
fact that there are
I've got
no
to
other
ask you a
cases that
question.
follow this similar fact pattern. That is what I think we focus on.
Okay, let me go through.
Every case is different.
Every case is different.
Has to be handled in the same way. Every individual, whether they are former secretary,
so there will be some cases,
has to be reviewed.
Madam General, I have very limited time.
And the law there.
General Lynch, you keep mentioning this professional team of career professionals. Were there any political appointees on that team? Any people who, in fact, did not work for the State Department, or did not work for the U.S. Attorney's Office prior to President Obama coming into office?
Well, again, with respect to the team, typically we don't go into the composition of it. It was led by our National Security Division.
Again, I'll ask the question with specificity. I'm not asking for names. Was there at least one person who was politically appointed that was on that team?
The investigative team was composed of career prosecutors and seasoned agents.
The question is, was there at least one that did not work a career, that was in fact an appointee, either confirmed or unconfirmed?
Congressman, I've replied to you as to the composition of the team.
Are there any legal prohibitions on you that Director Comey did not have?
Well, as I've indicated, it would not be appropriate in my role to discuss the specific facts and the law.
Is the legal prohibition against that, other than the fact that you just don't have the same knowledge about the case that Director Comey had?
We typically actually do not provide the level of detail that Director Comey did.
Is that just a choice that you make in not disclosing that information?
Well, as indicated, we obviously are not allowed to discuss certain types of information, for example, grand jury information, in any
we're
matter.
Not talking about grand jury information here, are we? What I want to know is, tell me, is there a legal reason that prohibits you from giving us information, or is that just a choice you have made?
Congressman, as I've indicated, the director and I had very different roles in this investigation.
General,
more information on this matter than in others.
I just need to know if there's a legal prohibition that prohibits you from disclosing information to this committee, or is that a choice you have made?
It would depend upon the nature of the information.
Questions
Certainly
that you've
there
been
would
asked
be.
that you've had, is there any legal prohibition that would prohibit you from giving the same information that Director Comey has given?
Well, with respect to the source of that information, if it came from the grand jury, that would be a legal prohibition. With respect to opinions
let the record say
about
that
the matter
there
of
is no
law,
legal
that's a different issue.
prohibition that can be cited here.
Looks to me like this investigation is hinging upon the meaning of extreme carelessness versus gross negligence. Do you actually see that there's a difference between those two words?
Congressman, I always start with the statute, with any review that is being done on any matter by the Department of Justice. And we look to the statute, legislative history, case law, and we look at the facts as are developed by an investigation and apply them.
You know, from my years of judging on the bench, your comment that discussion of the statute would require discussion of the facts, when he asked you about an element that's contained in the statute, Attorney General, that really sounds like an answer somebody would give who hadn't read the statute and was looking for a dodge to avoid talking about a statute with which they're not familiar. You are aware, and this doesn't require any discussion of any facts whatsoever, but you are aware that in 18 U.S.C. 793F, gross negligence is an element of the offense, are you not?
Congressman, I refer you to my statement that you just commented on.
You've given no indication whatsoever that you did any independent reading of the evidence, of the statements. Was Hillary Clinton's statement even recorded?
Congressman, I'm not going to discuss the specifics of that.
Does an individual need a security clearance to review or have access to classified material?
Congressman, that issue would be dependent upon the agency for whom they worked and the nature of the work that they did.
Can you give me an example where you don't need a security clearance to view classified material?
No, I believe, as I was going to say, they would.
Is it legal or illegal to share classified information with somebody who doesn't have a security clearance?
Certainly, depending upon how you view the statute, it could go any number of ways.
So you think there is a scenario in which you could share classified information with somebody who doesn't have the requisite security clearance?
No, I would not draw that conclusion. I would say that I'm not able to answer it as a hypothetical, but that there are a number of factors that would go into the decision, and one could have any number of results.
Is it legal or illegal to store, house, or retain classified information in a non-secure location?
Again, I would refer you to the statute. One could, in fact, have liability, again, depending upon the nature and facts and
Do you
circumstances.
have any examples of where it's legally acceptable to retain classified information in a non-secure location?
I don't have a hypothetical answer for that.
Is it legal or illegal to provide false testimony under oath?
There are a number of statutes that cover that, both at the federal and state level. There are a number of ways in which that could be found.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton?
What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute to determine whether the elements had been met.
But my specific question to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint?
Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Don't you think
Yes.
public perception in a single-track justice system is important enough that you could at least touch on what you thought was lacking? You have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally? Can
No,
you
just
clarify?
as a prosecutor. There's
My
involuntary
violent crimes
manslaughter,
have involved
there's reckless
for
homicide, there's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
The reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone.
I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to, but right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did, or whether President Clinton could do exactly what Secretary Clinton did. And I think that lack of clarity is bad for the Republic, quite frankly.